I'm John Giardinelli. I'm Association Counsel, and welcome to John's Rants. What we're going to do today is we're going to talk about some issues that have come up in professional standards. As you might have already heard, the Association's Professional Standards Department is considered one of the finest in the United States. In fact, the Administrator for Professional Standards is an invited speaker this year at the National Association of Realtors Convention down in San Diego, because frankly, you guys do so many things in a unique and innovative way. So I asked Lori to tell me, what's going on with professional standards? What kind of phone calls is she getting, so that I could rant about some things that you need to be careful of in your day-to-day practice. I also want to talk to you a little bit today about some things you can do to persuade someone that maybe their conduct is unbecoming and that they're going to get themselves in a lot of trouble, and then some things that Lori can help you with. So let's jump in. Again, today we're going to talk about professional standards programs, and current unethical conduct. Now, I want to say one thing before we get started. As you know, we record these, and so I don't know when you're going to be watching it. I'm recording it on November the 12th at 1 o'clock my time, 11 o'clock your time. As of right now, the National Association of Realtors is meeting in San Diego in order to discuss issues relating to the multiple listing service. On November 23rd, we're going to do a special rant. It's going to be live. So if you hear this between the 12th and the 23rd of November, you might want to put that on your calendar. I know that the staff is going to be sending out notifications inviting you to that. We're going to do it live. We're going to record it, but we're going to do it live to allow you to ask any questions you want about the multiple listing service. Now, I'm not going to be the one answering those questions. I'm going to host it. I've invited three incredibly special guests. Ed Zorn, who is the attorney for the CRMLS, your multiple listing service. He's also vice president, general counsel. He is going to be speaking on all sorts of issues relating to current MLS issues. And we're going to take a deeper dive into the future of the multiple listing service, particularly as it applies to the compensation model. In addition to Ed, which would be enough, frankly, most days, we're also going to have Stephen Mead, who is the current treasurer of CRMLS. He's a real estate broker, past president of Pacific West, and he is also on the board of directors of CRMLS. If that isn't enough, we're going to have Larry Black. Larry is currently a member of the CRMLS board of directors. He's also the president-elect next year at Tri-Counties and the past president of Tri-Counties. So, and he is also a broker. So this is going to be a really special program. I invite you to come in live. If you have any questions about the MLS, send them to Lori Smith ahead of time. She's sifting through them and she'll get them to me. So what's going on today with the Code of Ethics and Realtors, according to the calls that Lori gets in the office? Number one is interfering with other agents' exclusive representation. In California, that generally means I have an exclusive listing to sell a seller's property. Rarely in California does it mean I have an exclusive right to represent a buyer, but that does pop up. There is a contract for that. CAR has a form. The code specifically says that you are to take no action to interfere with the exclusive agency relationships of another. And so you've got three potential problems if you do that. And again, the Code of Ethics, Article 16, is very broad. And it says pretty much any action. And I've sat in on some of these hearings, And any action can be helping a person write a letter canceling the listing. It could be any number of relatively small things or big. Now, what problems could you get into? Well, Article 16 of the Code of Ethics is directly on point. If you violate Article 16 and a complaint is brought against you, it could result in a fine of up to $15,000. If there's an MLS rule that covers these issues, it could result in an MLS fine or even suspension from the MLS. Those could both be very serious problems for you. In addition, there could be a lawsuit brought against you for interfering with someone else's contract and or interfering with someone else's prospective economic advantage, and you could be sued for the damages resulting from that in civil court. And of course, that would require you to have your lawyer. If there's insurance coverage, pay your deductible, and even potentially be rejected from insurance if it's alleged that your acts were intentional. You could also induce someone to breach their contract, which could in turn be turned around against you, and you could again be sued in civil court. So those are pretty serious issues. Another problem that Lori is seeing has to do with the age-old problem, and it's been happening for a long time, of listing agents not turning over and presenting in an objective way the offers that come in from other agents. Under current rules, Article 1, Standard of Practice 1-7 says that if an agent who presents you with an offer makes a request in writing, you must advise them virtually immediately that you have in fact presented that offer to the seller. And if you didn't do that and you lied about it, obviously that could be fraud. But the simple failure to deliver an offer to a seller is a violation of Article 1 and maybe even Article 3. It is a breach of your fiduciary duty. And I talked to the Department of Real Estate people. If you fail to present all offers, and there are a number of reasons why you have to do that objectively, even after you go into escrow. If you fail to present all offers objectively, unless the seller has put in writing that they do not want any further offers, that is also a breach of the Department of Real Estate rules. And the way that's been coming up is that a seller finds out later that they did have other offers, that the offers weren't presented to them, and they file a complaint against you. That is almost always going to be investigated. So you've got both ethical issues, which could lead to substantial fines, again, potentially MLS issues, which we'll talk about next time, and problems with the Department of Real Estate, which could cost you a lot more than simply money. It could cost you the right to be a realtor. Another issue that comes up arises, frankly, out of being rude, and that is a failure to communicate or cooperate. Article 1 and Article 3 are involved here. You have a duty to continually communicate with your client, keep them current on what's going on with their transaction, and you also have a duty to cooperate with other real estate agents. Remember, when someone lists their house with you, it's not because they necessarily like you or want to see you make money. It's because you've told them you're going to put this in the multiple listing service. Hundreds and thousands of agents are going to potentially see this property, and you may end up getting a lot of offers, which is really what the seller wants. By failing to cooperate, you could be in violation of the Code of Ethics. You could be in violation of your contract with the listing office, with the seller. And of course, again, you could be in violation of the Department of Real Estate rules, because the Department of Real Estate is concerned with protecting consumers. And if the consumer is being harmed by whatever conduct you engage in, that could result in the Department of Real Estate calling on you. Another issue that comes up a lot, and this is just a creature of your education, but we're seeing an awful lot of agents who don't seem to be on top of their knowledge of forms. Now, this is going to get significantly more critical for you on December 14th, because as you've probably heard, the California Association of Realtors has completely revamped the residential purchase agreement. It's going from 10 to 16 pages. It's going to have a brand new look. In addition, there's going to be somewhere in the neighborhood of 60 to 70 forms that are going to be revised, that are going to be sunsetted, that are going to be introduced. And so you need to be aware of what forms are out there, because it goes part and parcel with your obligation to do a good job. And if you fail to do that, you could be in violation of your fiduciary duty. I will tell you that the association is putting on all kinds of classes, as is CAR. The difference is that most of the classes being put on by the association are free. I know I'm doing a few, and some other incredible brokers and leaders in your organization are doing several. In addition, there are other people that are making their knowledge and services available to you. Find a class, take a class. Personally, I don't believe you can learn the new form in one class. I think it's going to take more than that. In addition, there have been lots of other companies that want you to use their forms. And because you're not familiar with those forms, even if you have a really good working knowledge of the RPA, to interpret another contract that was not prepared by CAR could conceivably be considered practicing law without a license. So be very careful of using forms that you're not familiar with. And if you're not familiar with the CAR forms, get some education. Another issue that's come up arises out of Article 9, and that has to do with the use of DocuSign. Now, I believe and I think DocuSign is awesome. I live in Tennessee. I come back and forth into California, so I use DocuSign all the time, and I find it to be incredibly helpful. Here's the problem. What Lori is hearing, and what we've been hearing now for quite a while, is something that Barbara Betts calls an abdication of your responsibility. Just sending the forms over without going over those forms with your client is a violation of your duty under Article 1 and under Article 9. It could get you into some serious trouble with the Department of Real Estate. It's a violation of the Code of Ethics. And again, you want to be very, very careful. Send the forms ahead of time. Send them as early as possible. You're going to have a new 16-page contract coming up in December. You definitely want to send that out. There's a place on that new form where the clients are actually going to sign an affirmation that they have read all 16 pages. Well, if you just send it over filled out, ready to go, and ask them to initial it and sign it, that's clearly not going to solve your problem, and you're going to get yourself into some serious trouble. Another issue that seems to come up a lot, and I'm shocked, is the unauthorized access of agents and others to property that is for sale. Under Article 1, the listing agent is required to go over the issues of access with their client. That's been incredibly important, obviously, today and in the last year or two because of COVID-19 and the fact that you couldn't do showings and you had tenants in property you didn't want people in. So you need to make it clear what the seller wants for access. Are they okay with open houses? Are they okay with a lockbox? How do they want people to be allowed to come into their property? That is a duty that is owed by the listing agent. Under Article 3, The duty of buyer's agents is to comply with whatever instructions you are given. We've seen situations where people have given out their access code to lock boxes and all sorts of other things. Big mistakes. If you do it, it's gonna obviously be a violation of one of the code of ethics, possibly a violation of some MLS rules. It could be a violation of the Department of Real Estate rules because you fail to cooperate with your tenant, and then, or not your tenant, your seller, excuse me. And then lastly, it could be a tort. I defended a case out in Palm Springs where the agent allowed people into the property, and those people burglarized the property by stealing the people's identity, and there was a pretty significant lawsuit. Be careful of, next are photographs. So be careful of your photographs, be careful of your advertising, be careful of the words that you're using because of fair housing. You've got copyright issues. Obviously, advertising is generally covered by the Department of Real Estate, by the MLS, and by Article 12 of the Code of Ethics. And then the last thing that Lori pointed out to me is something that is cultural, I think, right now, and it's very, very sad. As an older person, that I've seen and many of you have probably would agree with me, that we've watched this country's cooperation and the way we treat each other just really disintegrate as we watch our leaders lead us into that level of public discourse and disintegration of the culture and public interchange and interactivity. Be kind to each other, right? The listing agent has a job, the buyer's agent has a job. People are looking at your industry right now like they've never looked at it before. And by failing to cooperate, by being rude, you give rise to issues with the Code of Ethics, the Department of Real Estate, potentially fair housing. If the person you're being rude to falls into a category that's considered protected. So it's just generally bad for your industry when, and I think the legal term is jerk, when you act like a jerk. So don't do that. Your jobs are hard enough. I've been representing realtors for 40 years now. I don't sue them, I only defend them. And I think your job is hard enough. And when you start doing things like what we're talking about, you are playing into the hands of the plaintiff's bar. All right, so what can you do if you're faced with unethical activity by another realtor? If it's an MLS violation, then you can contact the MLS. There's a little button and they'll take care of it for you. They do a great job over there. But the association is incredibly unique. A number of years ago, the board of directors got together and said, look, we want to do more than just have people file violations and hear complaints and all of that. We want to make it easier for the membership, and we want to take it to the next level, which you have done, beyond what anyone else is doing, to the point where both CAR and NAR have asked people like myself, Lori, others, to speak on what it is the association's doing. So you should be very proud. One of the things that is very unique is a program called RED. Only 2 associations in California and the nation use the program, Pacific West and Tri-Counties. It is, RED stands for Rapid Ethics Delivery. That is came from the marketing department. Lori and I wrote it up with some help from the people in my firm, and it is incredible. I'm going to tell you about it in a second, but I want you to hear a statistic. Over 95% of the calls that come in through the RED program result in a satisfactory resolution, where no one gets cited for an ethics violation, where the agent who feels that they're being victimized is satisfied with the outcome, and most importantly, the clients have been properly protected. So how does it work? Well, there's a questionnaire on the association's website. You fill it out. It's anonymous. You let Lori and her people know what's going on. You can fill out the questionnaire online. And then what will happen is staff will read it over. If they have any questions, they can contact you. But otherwise, they'll contact the other party for you and let them know that this complaint has come in, hear the other side of the story, and try to work out a satisfactory resolution. At the same time, they're also going to contact the broker of the agent who you believe is misbehaving, so that that broker can no longer claim they were unaware that the problem existed. So again, there's not going to be any discipline. It's just going to be an attempt to resolve it. It's incredibly successful. You will hear about the results usually within 2 or 3 business days. You can file it whenever you want. If there is, in that small group of cases where there is no satisfactory resolution, or it is determined that someone is committing fraud, purposeful discrimination, or is stealing from a client, the matter will be resolved. But if it's not, then we can always file a complaint, so long as the complaint is filed within 180 days after you become aware of the problem. So again, go to the association's website. Under professional standards, there is a ton of information, frequently asked questions, all kinds of stuff. It is a great program. The phones are ringing off the hook. Problems are being resolved. Members aren't coming after each other. And we still have the ability to go after the really bad guys who are out there doing really bad stuff. Okay. Another program that the association has is a phenomenal mediation program. You know, the RPA, current one, and the one coming out in December, both have mediation clauses that the sellers and the buyers are required to follow. Your listing agreement has mediation clauses. There's mediation clauses galore. Mediation can get very expensive. Now, the contract, the RPA, defaults to the CAR mediation program. But if you want to keep it closer to home, the association has a phenomenal mediation program. We have trained mediators. They've gone to many cases to the Pepperdine School. We have some lawyers that have signed on. All of them have agreed to provide a certain amount of free time, and then the cost is still incredibly and significantly lower than if you went to one of these other agencies. Lori and I have written up all of the materials necessary, and it's a great, great program. Much less expensive than going to one of the services that are out there, although they're great services. And if the case is too complex or too big, that might be your best choice. But if it's a small, relatively small dispute regarding the deposit or regarding repairs on the house, but not significant repairs, this is a great place to go, get the problem resolved, try to get it settled. You still have the right to arbitration, you still have the right to litigation. But again, over 85% of the cases that go to mediation settle. And that means no litigation. Guys like me aren't making more money off of people like you. And it's just a great idea. So hopefully you will avail yourselves of those services. They're unique to your association. In the meantime, remember that on the 23rd of November, we're going to be doing the special MLS rant. I'm going to be asking questions of the 3 panelists. You'll be entitled, if you come live, to answer questions or ask questions of the panelists. If you want to get those questions put to where you're at the front of the line, send them in now, and Lori will get them over to me before the 23rd. So with that, I've enjoyed today. Hopefully you've gotten some good information. Until the next rant, this is John Giardinelli signing off. Thank you very much.